His time has expired. Yeah. Congresswoman Norton, for 5 minutes.
Thank you, Mr. Chairman, and we do appreciate the transparency you're trying to bring to this transaction. I am not inclined to second guess the judgment of people in the midst of trying to deal with the problem rising, problem after problem, in the midst of a crisis, an unusual crisis at that. I am interested in Bank of America's options under the circumstances. Bank of America had shareholders. We did have a series of rather unusual, late developing facts or factors to come to light in the process of the negotiations for this agreement. I'm wondering if it would not be true that let me lay the predicate for this by saying you apparently, the legal division apparently had an opinion that no Delaware court had been found that, I'm quoting now, that have found a MAC or material adverse effect to have occurred in the context of a merger agreement. Well, one would have to know the facts surrounding those circumstances and to suppose that they could not possibly have been at the same level of intensity as these, because we're in the middle of a national economic crisis. That aside, I can understand from that one sentence that without knowing what the case law was, that there was that conclusion. But could not Bank of America have negotiated a reduction in price with Merrill had it invoked the MAC clause? Wouldn't you think that would be the logical thing to try to do, given the obligation to the shareholders?
First, we did review the case law, and I think it was quite applicable. I'm not a lawyer, but the advice I got was that it bore very directly on the situation that we were looking at, specifically that short-term losses, no matter how large, are not basis for a MAC in this particular case. Only long-term, durationally significant losses in revenue or revenue production are grounds. And of course, Merrill Lynch has proved to be a profitable acquisition for Bank of America. Why not negotiate a better price? That wasn't the issue that Lewis originally raised. He was talking about just breaking off the merger. But I think that would also have been very dangerous, because the markets would have been faced with the uncertainty of whether or not the deal was going to go through. Merrill Lynch would probably not be able to survive absent the support of Bank of America, and so there would have been an immediate problem with Merrill Lynch, which would have created broader problems in the financial markets. I don't think
even if they threatened to do that in the context of negotiating.
Well, you can't negotiate anything unless you're willing to go through with your threat.
Oh,
as you know,
that happens every day, Mr. Chairman.
So therefore, there would have to be a probability in the mind of market participants that, in fact, Bank of America would not go through with the merger.
So you think that would have been considered a bluff?
I think that would have been destabilizing as well, yes.
In consummating, though, the merger, as it was originally planned, in effect, didn't the Bank of America shareholders take a good part of the hit of the Merrill losses?
Not in our view. As I said, when I talked to Mr. Lewis about this, I stressed that not only was invoking the MAC bad for the financial system broadly, but I thought our opinion was that it would be bad for the Bank of America itself, and in particular, if the invoking the MAC had caused Bank of America either to fail or to have to be saved at some emergency basis by the government, that clearly would not have been good for the shareholders of Bank of America. Now, of course, in the end, he had to make the judgment of what to do, but that, in my opinion, it was not obvious at all that invoking the MAC was a good thing for the Bank of America shareholders.
And you think he made that decision on his own without undue influence from the government in any way?
I believe he did.
Thank you, Mr. Chairman.
Thank you very much. Mr. Chairman, I know we have an agreement that